All right, good evening, everyone. My name's Anita Seghetti. I'm the president of LAMDA, as most of you likely know, but if you don't, that's who I am. This is part 4 of LAMDA's
Wow.
CPD series on practicing before the Consent and Capacity Board. As those of you who have registered for the entire 7-part series know, there was an introduction to the practice that Shira Brass and I videotape that's available to you. It's actually on my blog if you want to watch that video. Um, Tayo, now you want to mute yourself.
Yeah, sorry, I'm having problems with my.
That's okay. You'll work it out. The second part was on capacity with Naomi Sayers and Danielle Lee Chong. We had a third session. We do them about once a month on involuntary admission with a bunch of people named Michael and Mitchell. And there are materials with respect to all those sessions. So this is part 4. This is a very hotly anticipated seminar because today's topic is community treatment orders. For those of you who practice frequently before the CCB, which is the target market here, you will know that hearings to review community treatment orders have skyrocketed in terms of the volume and the percentage of the applications made to the Consent and Capacity Board over the years. So they used to be a very small part of the workload of the board. And in the last, I would say, 5 years or so, they have become the second most common application. So reviews of involuntary committal are the most common, but community treatment orders have outpaced applications to review a finding of treatment incapacity. So there are a lot of community treatment orders out there, and there are many, many hearings of the Consent and Capacity Board in relation to community treatment orders. So we have 2 speakers today, and one of them has dropped off the Zoom for a minute, so we're going to have to wait to introduce her. This session is being recorded. All of our sessions in the 7-part series are being recorded, so there will be a video recording. There are also materials you have already received if you registered and you're here because of that, which should be everyone. There are materials that both our speakers have prepared that have been circulated prior to the session. You will also get a copy of the PowerPoint presentation that Tayo Dada will deliver, but you will get that along with the video recording after the session. In terms of CPD, if you're a member of the Law Society of Ontario, I think we're going to forego an application for professionalism. We'll get some of our other sessions accredited for professionalism and EDI. But I think in terms of this session, we're going to keep it to the substantive hours that we don't have to seek particular accreditation for, because you're going to be getting a lot of substantive law tonight. So you can claim, for having attended this session or to watch the videotape, you can claim 1.5 hours or 1 hour and 30 minutes is how they want you to put it, of substantive accreditation. Now there's Tayo, she's on her way back in. So I'll just let you know what I understand is the structure of the presentations tonight. Tayo Dada, who's rejoining us now, is going to be our first speaker. Tayo is going to be talking about the community treatment orders themselves. Her paper presentation sets out the applicable sections of the Mental Health Act with respect to the community treatment order regime and some cases around that. Tayo and Erin, Erin Holder is our second speaker. They both do a lot of these hearings. Tayo is a very accomplished lawyer. She's certified specialist in health law and also a marriage counselor. And we were talking about her book that she's published on marriage counseling, which I think is fascinating. So if you have questions about your marriage, you can ask about that. But please don't hold your questions till the end. Erin Holder is another accomplished sole practitioner who also does a lot of CTO hearings. And she'll be speaking with you today after Tayo's presentation on the orders. Erin's going to focus on the community treatment plans that underpin the orders. And you have some materials from her, including cases that relate to the contents of community treatment plans and what basis they may be challenged upon, and some precedent or sample treatment plans that she's seen in her practice. In terms of whether your video is on or off, I think we're going to ask you actually, well, it's up to you. I'm going to spotlight the speakers, but at the end of the presentation, I'm going to ask everyone who's able to please put your video camera on if you're able, so that we can take a group photo for our socials. So I think I've covered all the really boring preliminaries. And with that, I'm going to hand it over first, I think, to Tayo. So thank you, Tayo and Erin, for your time tonight. We're looking forward to an exciting evening. And hold your questions until the end. There will be time after the presentations for your questions, and then you can drop them in the chat. Or, well, you can drop them in the chat anytime, but we'll get to them at the end, or you can use your voice. Okay, Tayo, now you're off the screen.
I'm here.
Okay.
Can you just make me co-host once again?
I did. I just did.
Oh, no. Oh, just now? Oh, all right.
Yeah.
Awesome.
I got your chat. I'm multitasking. I was so proud of myself. Okay.
Okay.
So I'm gonna disappear, and thank you for doing this.
Okay. First of all, I want to say welcome to everyone. And I really want to appreciate the opportunity to be able to share, because I think it is a great opportunity. I also cannot go without acknowledging the work that Anita has done in this field. She is one of the first mentors that I had in the field at a time where there were so few people doing it. There was no one to ask questions. I'll never forget my first CCB matter. I literally was having a panic attack because I just didn't know what to do. And I'm so glad that we're doing this, because I know there are a lot of people that come into this field that are in that situation. Now, tonight, I'm going to share my screen. Just give me one moment. Hopefully I don't have any more tech issues. Okay, so can you give me a thumbs up if you can see my screen? Great.
Yes, we can see your skin.
Okay, great. So practicing CCB generally, one of the things I've found is that a lot of practitioners are reluctant to take on community treatment order matters. And I hear a lot of people say, oh, they're too complicated and it's so much stress. But I hope that as myself and Erin, my co-presenter tonight, address some of the core features and issues that relate to community treatment orders, I hope we're able to debunk the myths around it. I have sent out a paper, which I believe has been circulated to everyone. Just to try and keep me on time, I'm going to be using a PowerPoint, and I'll try to go through as quickly as I can. So first of all, I like talking about myself. So first of all, I'm going to talk about me. So I was called to the Nigerian Bar in 1985, Canadian Bar 2011. As Anita said, I am a certified specialist in health law. I'm also a certified counselor and social worker. I teach nonviolent crisis intervention. I'm a marriage coach and author. By Blacks decided to give me the Best Lawyer Award for 2019 within my community. And I'm also the first female president of the Canadian Association of Nigerian Lawyers. So that's where I just show off. Okay, now tonight, what are we going to be talking about? We are going to be doing an overview of the history of community treatment orders. We're going to be looking at legislative requirements with case law. I'm not going to be going through a lot of the case law because most of it is in the material. We're going to look at the content of the orders, some of the practical things like how do we obtain medicals, how do we prepare for a hearing, you know, what's the client interview supposed to be like? And for me, what keeps me on track in terms of preparation is the form and file review, which I think is really, really important in highlighting the issues that relate to community treatment orders. Now, I think it's important for us to touch on what the history is. I'm not going to go a deep dive, but community treatment orders were supposed to be the lesser evil, between a person staying in hospital and something happening in the community. So the main target of the community treatment order was the revolving door issue. And for those of you that have taken a look at the paper, one of the starting point really of legalizing and establishing constitutionally CTOs and the advent of the Box B criteria was Bryan's Law, the legacy of the Thompson Empowerment Council versus Ontario. Can you hear me? Okay, sorry, Ontario. And this was a case where an individual had been killed by somebody who was in hospital, had been released, and during that time had killed this individual. And so the law was really twofold. Number one, to take care of public safety and improve treatment for the mentally ill. The second part is honestly something that is still leaves us in wonder. I have a lot of clients that I work with on CTOs that literally ask me, is there anything I can do to go to jail? Because I'd rather be in jail than be on this CTO. So that tells you how they feel about being on a CTO. Just like Anita said, I'm just going to say that CTOs have multiplied, like it's astronomically over the last few years. And it's literally the fastest growing area when it comes to CCB matters. And one of the things is the pain is that there are so many people that have been issued maybe in 2019, they're talking about 5 or more CTOs. I have people that have been issued like over 7. It's almost the way my clients see it is it's almost like it's worse than a life sentence because it actually is a life sentence for them. They're like, you know what, if I go to jail, I'll do my time and then it will be okay. Everything will be fine. But unfortunately, that is what it is. And it's supposed to be less restrictive. Our clients find it definitely more coercive. And it totally, and I can say that I'm speaking from the voice and the eyes of the people that I serve in this community, and I do a lot of these. It just takes away who they are. And unfortunately, what I've come to realize is the board and the courts, to a large degree, honestly, do not appreciate the impact of these drugs. I remember having a client whose eyes rolled up, like every time he took the injection, his eyes rolled up and he'd be walking and he couldn't see. But that wasn't important. It wasn't important enough for anybody to really look into it, or even pay attention to what he was saying. And so this is, I'd say, part of the pain that we go through when we practice in this area, because it is kind of like quite emotional. Okay, so computer, do not freeze. Okay, just give me a moment. It looks like my computer just froze again. Okay, so the first thing we're going to do is very quickly look at the legislative requirements. I'm going to go through them as quickly as I can. Let's start with the purpose. We've talked about it. I'm just going to look at the second paragraph here that says, without limiting, and this is section 3313 of the Mental Health Act, the purpose is to provide a person who suffers from a serious mental disorder with a comprehensive plan of community-based treatment or care and supervision that is less restrictive than being detained in the psychiatric facility. So we all know what the purpose is. Now let's look at the criteria. Section 3311 of the Mental Health Act says, a physician may issue or renew a community treatment order with respect to a person for a purpose described in subsection 3 if the criteria set up in subsection 4 are met. And what this means is that all criteria must be met. Before we came online, we were talking about the stance that the board has been taking in terms of whether an individual is prejudiced. And it's very interesting when you have legislation that legislates what has to be done, and you are being asked to show prejudice. Like, the law isn't requiring you to show prejudice. The law is the law. I actually had this discussion with at a board hearing yesterday, where the doctor was saying things like, well, the spirit of the law is this. I'm like, no, the law is this. The law is the law. Unfortunately, sometimes we're heard, sometimes we're not, depending on who we are appearing before. Hogan and Whelan, this was a situation where the board had said this person was meeting a slippery slope towards meeting the criteria, and the court said no. Slippery slope towards meeting the criteria does not equal criteria being met. So what are the criteria set out in subsection 4? And if I'm going too fast, too slow, please just let me know. I'm just trying to move quickly because we have a lot to do. First criterion, has the patient been in a psychiatric facility on 2 or more separate occasions, or for a cumulative period of 30 days or more during the 3-year period? Or has that person been a subject of a previous community treatment order under this section? That is actually one of the things that's pretty easy to figure out, looking at the facts and the figures. But one of the things that has happened in a few cases, and more than once, where the doctor, and this happens when we're talking about the involuntary status, we need to know that the involuntary status impacts our clients, because the length of stay that they have in the hospital impacts whether they can be put on a CTO. And many times I've had doctors that are intentionally keeping an individual in hospital so that they qualify for a CTO. That is against the law. That is not the spirit of the Mental Health Act. And we need to be aware of that, and we need to address it when we're doing our involuntary status matters, to say, you know what, the criteria, part of the criteria for keeping a person in hospital is not so that they can qualify for a CTO. And in the case of JT, this was where the doctor was aware of the 30-day requirement. He knew it wouldn't be met. So what he did is he fabricated 2 separate admissions. He discharged the person, didn't let them out of the hospital, but then readmitted them and said that accounted for 2 admissions. And the board said, no, that's not what we're talking about. We have another case where the CTO was revoked, and the doctor considered it as, you know, well, it's still a renewal, and the board said no. The second criterion, the person or his or her substitute decision maker, the physician who is considering issuing or renewing the community treatment order, and any other health practitioner or person involved in the person's treatment or care or supervision have developed a community treatment plan for the person. Erin is going to be speaking extensively on this, so I'm just going to go to the next one because that's all she's going to be focusing on in her paper. The third criterion is the 72-hour rule. We've had some cases where the doctor has not done the assessment within the 72 hours. So when are we counting the 72 hours from? The period before entering into the community treatment plan. That is when that examination has to take place. And so you need to be observant when you're going through your material. You are looking at the dates. The dates really matter. Like I said, Erin's going to be talking a lot about CTP, so I'm not going to spend too much time. I know I did do a matter, GA and Cantor. That was one of the issues in that matter, was the fact that the doctor didn't do the examination within the 72 hours before entering the plan. And RESD says maintaining this chain of responsibility is of paramount importance in ensuring the consistency and currency of care offered to patients dealing with mental health issues. Now, the third criterion has 5 sub-criteria, which I'm going to dash through really quickly. The first sub-criteria is, does the person suffer from a mental disorder such that she needs continuing treatment or care while living in the community? So the core part of this is, does she or he need continuing treatment or care while living in the community? What kinds of evidence will the board consider? Past circumstances of the client, patterns of behavior prior to hospitalization. We need to pay attention to how dated the information that's being brought is. I had a matter I did today. I mean, the last time the person was in hospital was in 2010. The last time anything happened was in 2010. And the board said, no, you can't rely on evidence from 2010. The board will look at overall compliance with medication when in the community. Hearsay evidence will be considered, as we all know. It's important for us to raise the issue around the weight that should be attached to the hearsay evidence that is brought in. And I know that ML versus Rathi Tharan specifically speaks to that. And it speaks to the board being cautious, particularly when the hearsay evidence is coming from family members. Like when you have family members that say, well, I really want him to be in hospital. That's not enough for a person to be in hospital. The question is, have the criteria been met? And the board has always made it clear that determination should not be based on best interest. Like I said, all these cases are well laid out in the material, so I'm not going to go through them one by one. Now, the second sub-criteria is, does the person meet criteria for the completion of an application of a psychiatric assessment under Section 15.1 or 1.1, which is the Form 1. Now, when the board is looking at this criterion, what they are looking for is whether they would meet the criteria, but for the CTO. I know in the past we've tried to argue, at least I have tried to argue, that they don't meet that criteria, but the argument is always, well, but for the CTO, they would. So, and the logic behind that is, if the CTO is working well and keeping a person out of hospital, if we take the stance that I was taking, it would be held that every CTO would be invalid. So that's the logic behind that. Sub-criteria 3 is, if the person does not receive continuing treatment or care and continuing supervision while living in the community, he or her is likely, because of a mental disorder, to cause serious bodily harm to himself or herself or to another person, or to suffer substantial mental or physical deterioration of the person or serious physical impairment of the person. Now, most of the time, a lot of the time, where the doctor can, they are going to rely on substantial mental deterioration, just because it's more flux and so much easier to lean into. But what I want to say is, do not assume that because the doctor says that they're going to suffer substantial mental deterioration, and maybe your client has been sick, has been in and out of hospital, that's the end of the matter. Look behind it. Look behind it. Like, when last did he have frostbite? Or he went out with no shoes on. Was it winter? Was it summer? He was wearing 2 coats. So what happened? So there must be the nexus. There must be the connection. It's not enough to say, oh, well, he's been to hospital so many times. We have to look behind it. We have to, and what that speaks to, I'm going to talk about that a bit more later on, is we actually have to read the file. Like, you can't just read the doctor's summary. The doctor's summary is the doctor's case. You really do not say, because, oh, your client isn't sitting in front of you, your client's not going to ask you questions. The devil is in the detail. The doctor puts in what's convenient for him. There are so many things I've seen the doctor put in. And by the time I go through the file, I'm like, hold on, what about this and what about that? And you can only find that if you actually read the file. Okay. We've already had a lecture on each of these, like serious bodily harm, substantial mental deterioration. There have been instances where a person has actually hit someone and it's not been considered as serious bodily harm. The question is, was serious bodily harm caused? And sometimes the doctor will come up with things like, oh, there was psychological harm. Was this reported? Did the person need treatment? These are all the things that we need to go, okay. My assistant's like, it's on the next page, it's on the next page. So yes, serious physical impairment, harm due to inadvertence or retaliatory violence. Most of us are aware of this. Serious bodily harm to self means an intentional harm, more towards suicidal tendencies. Serious bodily harm to another person, it's hurt or injury to a person that interferes with their health or comfort that is more than trifling in nature. And then substantial mental deterioration, most of the boards have said there must be a marked regression from baseline functioning. I believe it's in NE, it says it's not enough to say, well, he's not going to be able to go to work. He's not going to get on in the community. Like he's not gonna, I had a matter recently where the doctor was like, she doesn't talk to her family. And I'm like, how old is she? Can she not choose who she wants to talk to? How does that become a ground for her to stay in hospital involuntarily or to be put on a CTO? Fortunately, the board agreed with me. Okay, sub-criteria 4 and 5, I'll take together. The person is able to comply with the community treatment plan contained in the community treatment order. The treatment or care and supervision required under the terms of the community treatment order are available in the community. I've put some notes here, but I'm going to leave that for Erin to deal with. The fourth criterion, and this is something that's come up quite a few times for me, and that is, has the physician consulted with the health practitioners or other persons proposed to be named in the community treatment plan? And I have had doctors that have said, well, it doesn't matter if they didn't consult with the CMHA or with CAMH or with the CHSMC, so long as it's the doctor. No, it's the health practitioner or other persons. Now, major takeaways, 3 matters, 2 that I was involved in, one at the appeal level, which is RG versus Leo, and LL. LL is a great case because it's re-LL. It kind of analyzes both Pitik and Leo in a way that makes it very clear. What are the takeaways? The physician must consult with the person named in the CTP. The consultation must take place before the community treatment plan is entered into. REGA highlights the fact that the community treatment plan is entered into the day it is signed by the doctor. The rationale behind this is that those involved in the CTO must be aware of the obligations under the plan and must be prepared to accept and fulfill those obligations. And I know Erin's going to be talking about the obligations. Now, the board is tending now to say it doesn't matter when the people that are going to be engaged in the plan signed the plan. All they want to see is that there was a discussion before the plan was signed. So that is something that I've been coming up against recently. The 5th criterion is subject to subsection 5, the physician is satisfied that the person subject to the order or his substitute decision maker, if any, have consulted with a rights advisor and have been advised of their legal rights. Now, the law is rights advice must be prompt. Rights advice is triggered once the Form 49, the notice of intention, is issued. To gauge whether rights advice was given at the right time, you need to look at the Form 50, which is the form from the PPAO. Now, the board is all over the place with this. I did an appeal recently, MLD, and what the court said, which is just highlighting really what's been going on at the board level, is there has to be, each case is dealt with on its own merits to start with, and that prompt is not capable of a bright line test, but it depends on the circumstances of each case. What I've seen the board is doing is looking to see, was there effort made to contact this person, and what was the effort made? What did the doctor do? So there have been matters that I have brought forward where the rights advisor will now write and say, or has written to the doctor and say, well, I called 10 times, this person didn't pick the phone, but that letter is not in your material it's not in the medical records. So you raise it. If they bring it up, sometimes I've said, okay, I concede. And other times I'm like, no, this isn't enough to show that rights advice was prompt. The sixth criterion, this is also something that I've had to use quite a bit, whether the person or his or her SDM consents to the community treatment plan in accordance with the rules for consent under the Healthcare Consent Act. And in dealing with this, we have to refer to section 10, 11, 21, and 22 of the Healthcare Consent Act. The physician must be in a position to articulate why they are at the time of the hearing satisfied the substitute consent on which they are relying is granted in accordance with the rules for consent set out in the HCCA. I believe that Erin is going to speak to the issue of prior capable wishes. And yeah, that's something that's come up. I think the doctors are getting wiser now, because like the last 3 or 4 files I've read have it written very clearly. Prior capable wishes discussed with the SDM. If prior capable wishes are not discussed with the SDM, honestly, it does vitiate the form. Okay, who needs to be given a copy of the CTO? The physician, the person, along with the notice that they have a right to a hearing before a board, the substitute decision maker, the officer in charge where applicable, and other health practitioners or persons named in the community plan. The CTO will be revoked if this procedural ground is not satisfied, and the cases are available for you to read in the PDF. Now, this is another slippery slope, and it's really impacting a lot when it comes to like preliminary issues. So the board is taking the position that certain things that say shall be done in the legislation fall under discretionary grounds. And so, you know what, they are not going to hear them as preliminary matters. They're going to let us go through 2 to 3 hours of hearing, plus, I mean, doing the prelims as part of the discussion. And then after everything, they are going to take a decision on whether they're going to exercise their discretion. My argument to the board has been and continues to be, if you are talking about saving time and money, that is a waste of time and money. Because if it is a ground, whether you can use that a discretionary ground, I know you want to establish that all the other grounds are met.
No gets life jackets. No
Sorry, you just see.
If you see anybody like that, you arrest the person.
You need to mute yourself.
I got it. Sorry, I'm on it.
Thank
As
you.
people come
No
in.
problem.
My apologies, Ty.
No problem. So, and section 39.1 subsection 7 makes it clear that the board can exercise, well, its discretionary power. The question always arises as to when. I've also found like the board is taking the position, even with the mandatory criteria, that they are going to hear the whole matter before. And I keep emphasizing, this is such a waste of time. If we know from the outset that there were no prior capable wishes, why do we need to go through 3 hours of hearing? But maybe that's something that Anita can deal with. That's for the big dogs to deal with. Okay, let's look at the content of the order. 36.1.16 holds that a community treatment order must indicate the date of the examination referred to in clause 4C, the facts on which the physician formed their opinion. Now, this is another ground on which we've gotten CTOs overturned quite a bit, but I am finding the board is becoming resistant to it. So even if there's one line that says, oh, they did something, they're just going to uphold the CTO. But I say to everybody, continue to push. It depends on the board you get, and it depends on how you align your facts sometimes. It's important for us to emphasize the impact that CTOs have and the importance of following the letter of the law to make sure that they are only enforced when they should be enforced. Section 33.16. Yeah, I just gave some examples of where the board has said. Now, the key thing here is the law requires the doctor to provide facts to support their opinion. In Form 45, that's the CTO. A lot of times, what happens is the doctor just repeats the opinion, which is supposed to provide facts to support. And my argument is, if you are just regurgitating what the opinion is, then it's not supported by facts. But like I said, it depends on the board you get, which is something that's common in this field. I'm going to leave this to Erin, which is undertaking obligations. I'm going to leave obligations to Erin. I'm going to go to, in the next 5 minutes that I have, some of the practical things. I've put in the paper because I get calls from people all the time asking, how do I get medicals? Where do I get medicals from? So what we've tried to do is put in a list of places that we have been able to get medicals from in respect of CTOs. Sometimes for inpatient, it's different from CTOs. And requests should be made to the hospital, the ACT team, if you know. If you don't know, ask the doctor and the CTO coordinator, say, I need medicals. Section 76 of the HCCA, they have an obligation to give you disclosure. Your client does not have to sign a consent because most of the time they can't and won't. So I've had to, I actually have it on, recall so that I can send it out. Make sure to double check the CTO records are in the documents. I can't tell you how many times, 2 days to the hearing, we're going through the documents and lo and behold, there's no CTO. You need to have the CTO forms and you need to make sure it's the current CTO forms. Don't assume,
why is it?
Don't assume that it's the current CTO
so that nobody thinks you're stealing it. Go get it.
The next thing, please be respectful, everybody. Mute yourselves if you are speaking. Preparation for the hearing. Please prepare your client. Most times, we don't call our clients to give evidence. Sometimes they will say they're not going to give evidence. Then they hear the doctor, they're so mad, they want to give evidence. My practice is before I even read anything that anyone has sent to me, I want to hear from the client if I'm able to. I want their opinion. I want them to tell me what's been happening to them. I want them to tell me what's their family dynamics before I get into the material and start to, have my head turned around by things that make you go, oh, wow, really? So make sure it's really important that you do a client interview and help your client to understand what the law is and what the board is looking for. Prepare for the hearing. I call it my form and file review. I actually have an actual form that I use for every area of this practice for involuntary status CTOs. Now, what am I looking for? 2 minutes. Form 49, has the person been subject to a previous community treatment order? information of the dates of finding of incapacity in order to know the date of the capacity assessment, the date the Form 49 was issued. It's important for rights advice. Who is the SDM? Because that's important for your approach when it comes to things like prior capable wishes and all that. Form 50, I've already said, cross-check with Form 49. When was rights advice given to the patient? When was rights advice given to the SDM? The Form 45, who issued it? It has to be the same doctor that issued the community treatment plan, that did the examination. Verify the date of the examination. Verify the date the former CTO expired. Was the person treated post-expiry of the CTO? What were the circumstances? Does it have the opinion of the doctor and the facts that the doctor is relying on? Does it have the expiry date of the CTO? These are all important facts. So I think I am, and I'm at the end of my presentation. Thank you so much for listening. And at this time, I am going to hand over to Erin, who is going to take us through the community.
Awesome.
Thank you. Tayo, do you want to stop sharing your screen?
Will do. Thank you.
Thank you. That was so helpful. There's lots of information there that I didn't know, and I think we've all benefited greatly. I put my running commentary to your presentation into the chat, largely for my own amusement. But thank you, Tayo. That was just fantastic.
Thank you.
Thank you so much. Okay, I'm going to spotlight Erin and take it away, Erin.
Hello, I hope my audio is working. Everyone can hear me okay. Just a couple of comments further to Tayo's comments on the importance of reading the file. I cannot emphasize this enough, and she's absolutely correct. When I request records for a community treatment order matter, I request the forms related to the current community treatment order. I request the forms related to a previous community treatment order, if any, and I request the last 6 months of clinical records by physicians, any other member of the treatment team, and I request any and all discharge summaries, regardless of the date that they've been issued or authored. So I request everything. You never know what is going to be in that record, and sometimes there is information in the previous 6 months worth of notes that is extremely helpful to your client's case. And I would also just make a comment quickly further to the frequency of which CTO documents are missing from the record. So this just happened to me yesterday. I requested exactly what I just set out that I usually request, and I just got a dump of records from the health records department. I looked through it, and it was all Form 3s, Form 1s, Form 3s, Form 5s, and I emailed them back, and I'm like, there's absolutely nothing in here that I asked for. So this is extremely common, and honestly make sure that those documents are in there, because it's going to be a back and forth sometimes and a fight to get these records. So that's the only other comments I would make on records and records to request. In terms of community treatment plans, so I circulated some materials. I realized that they are very, very brief and mostly consist or largely consist of a list of cases. I apologize to anyone who thought this was required reading. I am going to be sending around an annotated version. Part of the problem with kind of annotating all of these cases is that obviously they deal with multiple issues. So I'm using cases as examples for certain issues for the purpose of this presentation. And I'm going to send an annotated version around with kind of 1 or 2 lines as to, the purpose that I'm using them for today. But obviously they can be cross-referenced and they deal with other issues as well. So community treatment plans, what are they? Well, community treatment plans, it's the plan that the person who is subject to the CTO, in other words, your client, must follow. Why is it referred to as a community treatment plan? Because a community treatment plan is a form of treatment under the Healthcare Consent Act, Section 2. This means that a community treatment plan is its own form of treatment. So just as medications are a form of treatment, a community treatment plan is a form of treatment. The two are not the same. They are separate and distinct treatments. And the decision I've put in the materials, SS 2020, speaks to this. They are separate and distinct. The contents of the community treatment plan that's set out in section 33.7 of the Mental Health Act. It's in the materials. I'm not going to go through everything in detail because I'm going to be focusing on the obligations of the person who is subject to the community treatment order. The person's obligations, that's set out in section 31.1 sub 9 of the Mental Health Act. And this is kind of very bare bones. Attend appointments with the physician who issued or renewed the CTO, comply with the CTP as described in the CTO. I'm going to skip how to read the CTP and just give some examples of community treatment plan or CTP clauses. So CTPs can be either very, very bare bones, and a lot of physicians like to leave them, or whoever is drafting the community treatment plan. A lot of hospitals or physicians like to leave these very, very, very vague so that they can change as many things as possible over the course of the 6 months that the person is subject to the plan. Arguably, these community treatment plans are what I would call boilerplate, meaning they are too generic. They are not specific enough. Community treatment plans need to be tailored to the specific individual. So they cannot just be, or they're supposed to be tailored to the specific individual, not just, a template that can be applied to basically any person who is subject to a community treatment order. Community treatment plans, on the other hand, can be extremely detailed. At a bare minimum, generally, clauses that are included in a community treatment plan include medications that your client is obligated to accept and what will happen if they do not comply with the terms of a community treatment plan. So required medications, and if they do not comply with the terms of the community treatment plan, what can happen is that a Form 47 order for examination can be issued, which I'll explain in a couple of minutes. Well, actually, I'll explain it now. So if a person doesn't comply with the community treatment plan, basically, bottom line is they can be scooped up by the police and brought to hospital for the purpose of undergoing a psychiatric assessment. But before a Form 47 order can be issued to have the police come and scoop your client up, there are certain steps that are in the Mental Health Act, certain steps that a physician has to follow before issuing a Form 47 order. So this is set out in section 33.3 sub 2 of the Mental Health Act. Reasonable efforts have to be made to locate the person, inform the person of their failure to comply, or inform the person's substitute decision maker if that individual is incapable. Inform the person or the substitute decision maker of the possibility that the physician may issue an order for an examination and the possible consequences, and provide assistance to the person to comply with the terms of the order. In terms of how, and these clauses can be problematic. So clauses with respect to the medications that a client may be required to accept, those clauses can be problematic. Clauses related to Form 47 orders, those can be problematic. Specifically in relation to medications, for example, the community treatment plan may just simply state that your client is required to accept oral or injectable, say, antipsychotic medications, and that's it. There are some cases, for example, RK 2022, where it was argued that it's not enough to simply say that a client has to take oral or injectable antipsychotic medications or whatever the medication may be, that the medication needs to be, or the list of medications need to be specifically set out in the community treatment plan. There are other cases, for example, JA 2023, where the board has taken the position that, nope, it doesn't need to specify the list of medications. Taking oral or injectable antipsychotic medications is enough, no big deal. There are other problems that can come with, clauses related to medications. And I'm really trying to avoid getting into a discussion about clauses or provisions in a community treatment plan that are overly broad and or vague. This is probably the most common problem that arises with a community treatment plan. However, it's generally or used to be regarded as a preliminary issue, and there's going to be a separate CPD in the fall that's specifically going to deal with preliminary issues. So I'm really trying to veer away from overly broad and or vague issues. But for example, in a case MP 2018, there was a provision that said that the client was required to accept oral or injectable antipsychotic medications. And then the second sentence in that community treatment plan said medications may be changed. In that particular case, I believe the board, felt that the second sentence beginning with medications was, not clear, that medications could be interpreted as meaning, medications over and above, or medications that were different than antipsychotic medications, and found the community treatment plan was not clear based on that. There are other decisions of the board, however, that go the other way, saying that, the second sentence starting with medications, well, that's, perfectly clear. It simply refers back to the first sentence that speaks to antipsychotic medications or whatever the medication is. So in terms of kind of medications being specific, there's, decisions of the board that go both ways in terms of, medications not referring specifically back to what the client is required to accept. Again, there are decisions that kind of go both ways. One decision, and this was a decision of mine, PL 2023, and this is, I believe, included in the example community treatment plans that I sent out. I'm just checking to see which one it was. It's actually the first. So there's three examples of community treatment plans in the materials that I circulated. I know it's all one document, but this is in the first community treatment plan, and it's on kind of page 2 of 5 in the PDF. So this was kind of a case where the clause C as part of the medication clause basically said, the SDM's consent was obtained for the following medications. And then there's, like a whole list of medications: Abilify, Maintena, lithium, Epival. My client was not on all of these medications. And in fact, I think he was only on the Abilify, Maintena, intramuscular injection every 4 weeks. And the other medications were basically included, just in case the physician wanted to add them later. And the board in this particular case was like, no, which, you rarely get, but the board was like, no, this list is over inclusive. There's no evidence that this client, my client's even on any of the other medications, or that a capacity assessment has been done with respect to, lithium or mood stabilizers. So this is over inclusive, and they revoked the community treatment order on that basis, because the community treatment plan in that sense was, contained medications that my client was presumptively capable of consenting or refusing to consent to, and that didn't fly. Problems that can arise with Form 47 orders. So in DH, there's a case DH 2019, where, generally speaking, first of all, I'll say that generally speaking, the community treatment plan has to contain some sort of statement that about the consequences that you know a person is going to have if they don't comply with the community treatment plan. That they're going to be scooped up by the police, that this Form 47 order can be issued if they don't comply. So there's certain cases where, you know, the board has revoked a community treatment order based on the fact that there was no information in the community treatment plan about the steps that the physician was required to take before issuing a Form 47 order. So those are the steps that are set out in the Mental Health Act. There's a decision, this is DW 2001, where the board took the position that, you know, it wasn't, the Form 47 clause was not specific enough in setting out the consequences. So not just the steps, but specifically the consequences, namely that if the client did not comply with the community treatment order, he could be apprehended by the police. And the board took the position that kind of given the severity of the consequences of noncompliance, the specific terms of the person's obligations needed to be clearly set out in the community treatment plan, and in that case, it wasn't. So those are some, you know, issues that can arise with respect to provisions related to medications, provisions related to Form 47 orders. Then there's the issue of decisions that include a statement. So this also relates to Form 47 orders and noncompliance. There's decisions that will say, or community treatment plans that will say, if the person does not comply with the community treatment plan, then a Form 47 order will be issued as per the Mental Health Act. This drives me bonkers. The community treatment plan needs to be read within the four corners of the document. So this kind of brings me back up to my earlier heading, how to read the CTP. The community treatment plan needs to be read within the four corners of the document, notwithstanding any conversations that may have occurred outside. It needs to be read on the face of the plan. So when you know a clause is included or a provision is included that says a Form 47 order may be issued as per the Mental Health Act, well, your client's not going to know what that means. Well, they might, but you know most clients won't. You know, unless they happen to have a copy of the Mental Health Act handy that they can whip out and you know look up Section 33.3 sub 2 to find out you know what the steps are and then you know what can happen. And I've, you know, tried to make this argument a couple of times. Actually, I haven't had a chance to make this argument. I've prepared it to present, but never actually got that far. But you know, my position on this type of clause is that it's not sufficient. You know, it doesn't matter what the doctor will say. You know, oh well, I understand. Obviously, I know what the steps are. It says as per the Mental Health Act, and the board will say, well, we know what the steps are. It says as per the Mental Health Act. Well, it may be very nice that the board understands what the provision means, and it may be very nice that the doctor understands what the provision means. But who's the most important person here? Your client. Your client needs to understand what that means. And you know, reading the document on the face of it, it's not clear. There are some Form 47 clauses that are a little bit weird. So, for example, in the community treatment plan examples that I set out or I provided, there's an example, and this is kind of on page 4 out of 5 of the PDF. So, so here we go. However, if the client's symptoms become too difficult to treat in the community, or if she does not comply with her obligations outlined in the community treatment plan and her mental health status is negatively impacted, then the following could happen. Okay, so this imports a whole bunch of conditions over and above whether or not my client is complying with the community treatment plan. And this provision or this type of clause was addressed in the decision that I've referenced under case law and decisions for orders for examination, DM 2023. And the board basically, took the position, just as I said, that it imported a whole bunch of conditions into the clause. For example, if her symptoms become too difficult to treat, that's not a reason for issuing a Form 47 order. If her mental health status is negatively impacted, that has nothing to do with complying with the community treatment plan and issuing a Form 47 order. So in that particular case, that was one of the reasons why the board revoked the community treatment order, based on the wordiness and the clauses or the conditions that were imported into this clause that had nothing to do with my client's compliance with the plan. I actually didn't time this presentation, so we're just kind of moving along here, and we'll see where we get. Other types of clauses that can be included in a community treatment plan. So there can be provisions related to your client's obligation to attend meetings with, for example, an ACT team. There may be provisions requiring your client to attend for blood work. This could be a whole other 45 minutes, but we'll see how we do. There can be, you can basically include anything, but most commonly, other than medications and the Form 47 clauses, there's, usually obligations or commonly obligations to meet with some sort of community treatment team. And in some instances, go for lab work, and in some unusual cases, attend for urine screens, which I'll get into in a minute. One of the problems that can exist with other provisions or all provisions in a community treatment plan is what would best be described as a lack of kind of corresponding obligations. So I'll give you an example. In this is the last page of the example community treatment plans that I provided. So page 5 out of 5 of that PDF. So this community treatment plan in the second provision basically states that the physician will be available to see the client every 4 to 12 weeks at designated appointments, blah, blah, blah. The community treatment plan does not contain any clause that obligates the client to meet with the physician. So there's no corresponding obligation in this particular community treatment plan for the client to attend appointments. There's, an obligation, or apparently, the doctor is going to be available to meet with the client, but there's no obligation for the client to attend appointments with the physician. If the obligations in a community treatment plan, if there's no corresponding obligations, or if this kind of situation arises, this is a good reason for having or for taking the position that a community treatment order should be revoked. If the community treatment plan has, things that the doctor is going to do, but doesn't require your client to actually, reciprocate in meeting with the doctor, or whatever the clause may be. So for example, again, in that particular community treatment plan, community follow-up will meet with the ACTT or the ACT team. If there's no corresponding obligation for the client to meet with the ACT team, or there's no corresponding obligation for the client to meet with whomever, that can be a good reason for having the community treatment plan or the community treatment order revoked. Because it's the client's obligations that need to be set out in the community treatment plan, not what the doctor is going to be available to do, not what the ACT team is going to be available to do, but what your client is obligated to do pursuant to the plan. Lab work and urine screens. So provisions related to attending for lab work and blood work. So this is, we'll see if I can get through this in a way that makes sense. So first of all, blood work is more specific than lab work. Obviously, blood work relates specifically to blood work. Lab work can relate to blood work, or it can relate to, I don't know, any ECGs, other types of kind of clinical testing. The bottom line is that blood work or lab work, if it's included in a community treatment plan, it needs to be an ancillary treatment. And what I mean by that is that the community treatment plan needs to specify, or should specify, that the blood work that the client is being required to attend for is required for what is usually described as metabolic monitoring of the side effects of, for example, antipsychotic medications. If the blood work clause or the lab work clause is too general and does not specifically relate to the primary treatment that that your client is obligated to accept, again, this is problematic. So, and the same thing goes for, provisions related to urine screens. I've only actually seen 2 community treatment plans that have included a requirement that the client attend for urine tox screens, but that's equally problematic. And this is also addressed in the case I referred to previously, DM 2023. Basically, the panel in that particular case took the position that the term laboratory investigations was not defined. There was no indication that such investigations would be restricted to those necessary to treat my client's primary psychiatric disorder. And that imposing undefined obligations on persons to accept treatment would render it impossible for them to be aware of their obligations under the community treatment plan. It talked about the urine tox screen in a similar context, that there was no evidence to support a conclusion that this was an ancillary treatment to the treatment of my client's primary psychiatric illness. So in that particular case, this was the case with the weird Form 47 clause as well. So for kind of all of those reasons, the board revoked the CTO in that case based on the fact that this community treatment plan was particularly unclear and poorly drafted. Other problems with community treatment plans, there can be errors. A lot of times the board will say, oh, well, it's an error in the name of the SDM, which is actually a significant problem. But, a lot of times the board will say, oh, that's just, a minor clerical error, no big deal. But in other cases, the errors, can be arguably enough to have a community treatment order revoked. So, for example, the decision of SA 2023, and also AS 2021. In these particular cases, the errors were such that it was known in advance that these were mistakes. So, for example, in the case of SA 2023. The community treatment plan, required my client to accept a dose or Invega Sustenna at 150 milligrams every, 4 weeks or whatever. And the dose was wrong. Also, it had his place of residence incorrect. And what the board kind of took into account in that case was not so much the error itself, but the fact that it was known in advance, it was known prior to drafting this community treatment plan, that the correct dose was 100 milligrams, not 150 milligrams, and that my client lived in Toronto and not in Sudbury. So based on the fact that this was information that the physician knew before the community treatment plan even existed, the board took the position that, that was significant enough to have the community treatment order revoked because the community treatment plan contained errors. Consenting to the community treatment plan. So I'm going to go through this really quickly because I'm running out of time. The doctor's signature, always required. on the community treatment plan within 72 hours of conducting the assessment. Other signatures, not so much. Consent always has to be provided by the substitute decision maker to the community treatment plan, not to the community treatment order, to the community treatment plan. It cannot be to a historic community treatment plan or a previous community treatment plan. It has to be to the current community treatment plan. And the board has also taken the position that an SDM cannot consent to a community treatment plan that they haven't seen. So that those two kind of, principles, number one, that the SDM has to consent to the current plan, and that the STM should, really actually see a copy of the plan before they've provided their consent. That's set out in two cases, BB 2020 and KM 2019. Okay, so here's the big part, assessments. Assessments regarding the CTP. Okay, so there was before GA and Cantor came along, the board generally did take the position that a capacity assessment was required for issuing a Form 49. Form 49 being, the document that says, hey, you're up for renewal. There is a very small subset of cases. An example would be YQ 2022, where the board took the position that, nope, there's no assessment required. It's just a determination of capacity. Now, I don't actually know. I had trouble following the logic in this line of cases, but nevertheless, the position seemed to be that, there just had to be a determination at any point in time that the client was incapable, and that was enough. So no. GA and Cantor came along, and among other things, in my opinion, and in the opinion, or the board has, seemingly accepted, that this particular case establishes the principle that a capacity assessment needs to be done for the purpose of issuing a Form 49. Okay. This has to be done for each and every community treatment order. Each and every community treatment order, if there's a new community treatment order, there's a new assessment for the community treatment plan that corresponds to that order, even if the community treatment plan is identical to the previous community treatment plan. There has to be a separate assessment conducted with respect to the community treatment plan. So I was talking before about how medications, community treatment plans, separate and distinct treatments. There cannot be, the doctor cannot do an assessment regarding, medications and say that the client is also therefore incapable with respect to the community treatment plan. Okay, that no dice. Separate assessment for community treatment plan, separate assessment for medications. They're not the same. Another example would be, saying that conflating the assessments and saying, or the doctor saying, I did an assessment related to medications, and that's it. And it doesn't actually, the assessment note doesn't actually speak to the community treatment plan at all. It's generally not enough to highlight the main provisions of a community treatment plan. And it's not enough just to read the community treatment plan to a client. Well, that's my position, anyways. The assessment that is done needs to specifically refer to both branches of the test for capacity. So whether or not the client understands the information related to the community treatment plan, so all of the information in it, and whether or not the client is able to appreciate the information in it, whether the client can apply it to themselves. This is usually not done. Sometimes you'll see in an assessment note, oh, we just, CTP reviewed with the client. So, reading a community treatment plan to a client is not enough. This is basically like if you were doing an assessment, regarding medication and you read a product monograph to a client. That's not an assessment. So the assessment needs to refer to both branches of the test. The assessment needs to be a distinct assessment than the assessment done for medication. And the assessment, like when the physician is talking to the client about the community treatment plan, it's more than just medications. finding someone incapable to a community treatment plan because they may be incapable with respect to medications, while that doesn't necessarily mean that the client finds no benefits to other clauses in the community treatment plan. So for example, the client may say, oh, well, I really find the visits from the ACT team to be to help me out. I find it supportive. I really benefit from those visits. So there's a whole bunch of cases here that I've set out. MS 2020, new assessment for every community treatment order. Every community treatment order comes with a new community treatment plan. A new assessment has to be done. TW 2020, new assessment, even if the CTP is identical to the CTP related to a previous community treatment order. KM 2023, not enough to highlight the main provisions in the community treatment plan. GH 2017, got to refer to both branches of the test. EM 2022, not the same as medications, has to be a separate assessment. The client also has to be, and GH 2023 speaks to the fact that, it's not just medications, it can be other things that the client finds beneficial that may, mean that they're capable of consenting to the community treatment plan, such as visits or, meetings with the ACT team. In addition to the capacity assessment that is done for the purpose of issuing the Form 49, the capacity assessment, the client also needs to be, the capacity assessment needs to be also as of the date of the hearing. So I've included a case AF 2023, which speaks to a whole lot of issues, but also specifically the fact that, the capacity needs to be assessed for the purpose of issuing the Form 49. And it's also obviously relevant what the client's capacity is as of the date of the hearing, not in relation to medication, but in relation to the community treatment plan. Documentation. So this is becoming a more difficult issue to argue. It would seem like it's common sense that a conversation about the community treatment plan would need to be documented. Obviously, it's kind of a critical assessment. But what I'm kind of finding is that this there's nothing almost in the note related to the assessment. It kind of just says CTP reviewed, and this is becoming more and more acceptable, whereas I find that even like a year or so ago, documentation of the actual capacity assessment was specifically required. But what I'm getting now, I'll ask, when I cross-examine a doctor and I say, what did you discuss with the client about the CTP? The doctor will say, oh, everything. And, I'll be like, well, what do you mean by everything? And the doctor will say, well, we reviewed the CTP. And I'll say, well, where is this discussion documented? And the doctor will say, oh, it's documented in my note. And I'll say, okay, can you point to where in your note this is documented? And the doctor will say, it's documented where I, wrote, we reviewed the CTP, so at that point, I'm kind of ready to blow my brains out. But there are, cases that actually still take the position that it's critical to document the conversation or the capacity assessment, referring to both branches of the community treatment plan. Specifically, this is, I put a case in JW 2022 where this is required. I've already spoken to capacity as of the date of the hearing. I'm going to skip the part relevant to appeals. I might come back to that later, but I do want to just comment
Sorry,
briefly.
Erin, I don't mean to interrupt you, but I'm going to, because we have 9 minutes left of the evening. We're ending at 7:30. So
this will be my last comment then. And in terms of procedural fairness, I was going to speak to that as well, but the cases that I provided under that list just speak to instances where the client has suffered prejudice and the community treatment order has been revoked on that basis. So the last comment I'll make is, to watch for reverse onus assessments, which is where the doctor requires the client to prove that they're capable rather than, presuming the client capable and making a finding of incapacity. And if a client is found capable regarding a CTP, then the CTO will be revoked, because then that person is capable regarding the CTP and would have needed to provided their consent. And that kind of sums up everything I had to say in a very quick nutshell. I'm
Okay.
done.
Thank you for that. I didn't mean to cut you off. I'm not sure how many questions we may have, or whether there are any. There's definitely one question from Shira Brass in the chat. And Shira has asked, I have sometimes seen CTPs where the signature of the SDM is not dated. We know the SDM has to sign it before the doctor. How do you approach this issue? Erin?
So I had this come up. Hello?
Yeah, can you hear you?
Sorry. Am I answering this question?
Yes.
Yes. Okay. So I had this come up in a case that's actually in the list that I provided on consent to the CTP that I actually didn't speak to. The consent from the SDM should absolutely has to be provided before the community treatment order, the Form 45, is signed. If they don't provide consent, before the order is issued, then that's grounds to have the CTO revoked. Otherwise, they technically should provide consent kind of after they have received rights advice, but I think the board has gone both ways on whether or not that's absolutely required or not.
Sorry, so the SDM, what about their signature on the plan? Because here's why I ask. I don't know why I'm suddenly so big. Everyone should be the same size. So what I've always thought about the CTO regime is that we should be able to get them coming or going, right? Because the legislation itself is inherently incapable of making sense. The chronology cannot be fixed, right? So when is the SDM supposed to consent to the CTP? When do they consent to the CTO? And when do they participate in the development of the plan? Because they have to do that too. So before the plan is born, it has to be done with the participation of the physician and either the capable subject or their SDM. Like the SDM can't just be presented with a plan and their consent sought. The plan itself has to be developed with the SDM, right? So you can usually like poke at it, right? Like were they involved with at that early stage? So I don't know. I think there's enough there that you should be able to make something out of the timing of the participation of the SDM. And I just wonder what you guys think about that.
Yeah, what I'm finding is that the board is looking more to the facts of when were their discussions. Is there documentation of the doctor speaking to the SDM? When did those discussions take place? I actually haven't come across where the board has upheld a CTO where the SDM didn't sign the CTP. I haven't really come across that, because I would really argue that vehemently, because they have to sign before the or at the same time as the doctor. I haven't had to deal with that. But the board is continually taking the position that I actually had this yesterday, had a reading on this yesterday, that so long as there's evidence that there was a discussion, they accept that as consultation. But I would really argue vehemently if the CTP is not signed by the SDM, even if the CTO is signed by the SDM.
There is I don't know if anyone else has any questions. You can interrupt with your voice. I don't see anything else in the chat. We didn't really have a chance to unpack this, but I'm sure we'll have a follow-up session one day. My personal biggest beef with the whole of the CTO regime is issuing physicians or delegated physicians or supervising physicians they're downplaying their own role in the whole thing because of the machinery that is the community treatment order coordination. So I've certainly seen lots of CTOs where you're asking the doctor, did you provide copies of the documents to the patient? Did you explain this and that? And oftentimes they'll just be like, that's not my problem. That's not my job. Our CTO coordinator mails things out. They draw. So sometimes you get the feeling that it's the CTO coordinator who prints off last year's or the last CTO and then puts it in front of the doctor to sign. And that these things are done in a very rote fashion. And I think it's important to remind our members and our attendees today that that physician is responsible for everything. Just because the CTO coordinator is administrative staff, they can help photocopy documents, but they're not supposed to weigh in on the content or create the content. But these are things that happen between the issuing physician and either the subject or the SDM. Am I right about that? Do you guys find this scenario still? Where the CTO coordinator is just sort of running the show and the doctor flies in to sign off on stuff? Is that still seen?
I've had that come up. I've had that come up, you know, in terms of so I actually just recently had that come up in terms of in a case where there was a 66-day delay in issuing the CTO, and the doctor, you know, was on vacation for a lot of it, and then, you know, took the position, oh, well, it's the CTO coordinator's job. She should have sent out the copies. She should have done everything. And in that case, fortunately, the board didn't buy it, and, you know, said that, you know, during the 66 days, you know, my client suffered a lot of prejudice, and it was ultimately the doctor's responsibility to ensure that it was issued in a timely fashion. So yeah, they do try to shuffle things off to the CTO coordinators quite a bit. But, you know, some panels may find that acceptable, but other panels certainly don't.
And I think part of it is reading the file, because otherwise you don't even know that's what happened. Like, you actually have to find the facts in the details in the medical records.
And I think we've had cases where the doctor even tried to suggest that it was the CTO coordinator who got the consent of the SDM to the plan, because there was a period of time where the CTO coordinator would just call the mom or whatever and go, we're going to do the same plan again this year, mom, okay? And then they're like, okay. And then they're like, doctor, and mom said, fine. So all these obligations are the doctor's obligations, right? And I guess one last thing, we're at 7:29, I'm going to ask for a group photo. I will give you each last word, Tayo and Erin. But I did want to say, I think for those of us who are maybe new to the practice, I had a colleague once who described to me what his experience is in representing people who are on CTOs before the CCB. And he basically described it as, your opponent is not the issuing physician. Your opponent is the hearing panel. They are so committed as an institution to upholding these community treatment orders that they will find of their own motion often very creative arguments to try and support confirming these orders. And my colleague described it as a tennis match. You know, you served your preliminary objection and your problem with the order, and the board serves it back to you. And that's who you're volleying with. And I think that is a problem. I think that there is palpably in the jurisprudence a commitment to confirming these orders as a benevolent thing that is helpful to people. And I think what Tayo said at the outset is really important, which is coercion is not a dirty word in attaching to community treatment order. Case law recognizes that these are coercive mechanisms. People are being forced and forcibly administered things against their will under pain of threat of detention. So we can confidently say that they are coercive of liberties and liberty depriving. And I think you're right, Ty. The board doesn't entirely understand that. They really think that all these 10,000 people on these orders would otherwise be in hospital. And we know that's not true. They would otherwise just be free. So I think all these points are important to drive home. Before we take our photo, last word, Tayo.
Remember who you're serving, and remember who your client is. and fight for your clients. It doesn't matter what the board is saying right now. Keep fighting. I believe we keep fighting until we establish. And another thing, just to say, be careful about appeals. Make sure, like I'm very wary of that. We didn't talk about that today, but keep fighting for your clients. Read the file, represent them to the best of your ability. Something you said, Anita, before I ever started this practice is if you cannot emotionally regulate yourself to fail a lot, you can't be in this field.
Yes, that's true.
So just emotionally regulate yourself, but keep on fighting.
Yeah. Yeah, you really got to immunize yourself against being upset by losses. You gotta love the losses. Yeah, it's not about win or lose. I think it's really how you play the game. You got to play the long game too, right?
Yeah.
Erin, last word.
Try anything. Even if the case law or prior decisions are stacked against you, try it anyway. Try any argument, because you have no idea who your panel is going to be that day. You have no idea how they're going to, respond to the argument. It doesn't matter. Just try it anyway.
Yeah, because at the board level, if you lose, you lose. Who cares? Doesn't bind anyone. I agree with Tayo that your consideration of trying anything on an appeal is different now. So we'll talk about that another time. Okay, so I'm asking everyone who's able to turn your video cameras on to do so now, so we can take our picture. And I'm going to count to 3, and we're going to say, I want to say 1, 2, 3 dead SDMs, but maybe we'll just say 1, 2, 3 CTOs. I still can't shake this idea that we're going to sit with the clients and say, now, if your SDM were to die, that would terminate this order. That's just a recent case. We wanted to update you. I guess we can't. Okay. 1, 2, 3 CTOs. There. I'll do another one just to make sure. Hang on. Oh, I've got 2 screens worth of people. As you know, my favorite is when people smile and they're not actually on the screen, but smile anyway. 1, 2, 3 CTOs. And let me try and find the other screen. Hang on. There. Okay. I'm not on the screen, so now I can't tell, but 1, 2, 3 and smile. Okay, perfect. Thank you so much, everyone. That was really great session. All clapping hands for Erin and Tayo, and there's some really good materials as well, and more materials are coming. So thank you so much.
Thank you so much.
Thanks, everyone.
Hey, Tayo, I want to ask you a question. You want to stick around for a sec?
Yeah. Thank you so much, everybody.
Bye, Erin Fitzpatrick. Oh, I should stop the recording. That's the other thing that happens to every one of these things. How do we stop the recording? Where it says stop recording.